Thank you. Good morning. May it please the court, my name is George Lewis Pla, and I'm here on behalf of the wife, appellant Catherine Harding. Miss Harding asked that the court reverse the trial court's decision in part and order the trial court to instruct the company, or instruct the trial court to order the company to redeem the shares that Mrs. Harding was awarded at the agreed value of $3,500 per share, which was the agreed value for the year 2012. Why does Mrs. Harding believe that the court should instruct the trial court? Simply because the trial court created a separate class of shareholder in the Robbins Company. One where Mrs. Harding bears all the risk of being a shareholder, but does not bear any of the benefits of being a shareholder. The record is void of any evidence where any other shareholder was not an employee of the company or did not provide a service to the company. Mrs. Harding is the only shareholder that is in that category. As such, all the other shareholders last year received some compensation from the company. Mrs. Harding did not. All the other shareholders received a car from the company last year. Mrs. Harding did not. The other shareholders received travel reimbursement, health insurance, and other financial benefits which Mrs. Harding did not receive as a result of the transfer. Why should the court value it at the agreed value of $3,500 per share, which is the 2012 valuation? At the outset, the company's closed corporation agreement requires that a disassociating member sell her shares back to the company at the agreed value. And this is in Article 11 of the closed corporation agreement, which is Plaintiff's Exhibit 1. The court acknowledged this fact in its opinion in paragraph 24 and paragraph 25, when it said that the company conducts an annual valuation audit to determine the fair market value of its stock, and that the company valuation determines what the fair market value of the stock is for the purposes of the company conducting business. And the Robbins fair market value is documented not only in the company's board of directors meeting minutes, which on the records were Plaintiff's Exhibits 4 through 6 and Plaintiff's Exhibits 8 through 12, but it's published annually in the company's consolidated financial statements, which are used for all the company's businesses. And the court further acknowledged that on at least 4 separate occasions prior to Mrs. Harding, when a shareholder dissociated its association with the company's practice was to repurchase the shares. And the evidence on the record shows Plaintiff's Exhibit 21 and 22, the subordination agreements of James E. Rose and Joyce Lafiara. And that demonstrated that the repurchase could be done and be subordinated to Crystal Financial. And both Mr. Rose and Ms. Carley were receiving a financial benefit, even though they couldn't receive their principal back at the time. Both of them were entitled to receive and were in fact receiving interest from the repurchase. And in this case, that would have been a substantial amount of money that Mrs. Harding would have had last year. Mrs. Harding also wishes or asks this court to instruct the court to value the promissory notes at face value. And this is really a very straightforward argument. The undisputed evidence in the record demonstrates that Robbins International paid Mr. Harding a dividend, for which Mr. Harding then lent a portion of that dividend back to the Robbins Company. Mr. Harding paid taxes on the dividends that he received, and it's undisputed as to the value that he gave to the company, as evidenced by the promissory note. Now, the court in its decision said that it really couldn't determine what the value of the notes were because the company at the time was having some financial troubles and there was an uncertainty as to whether or not the company could pay the notes back. But that argument is irrelevant because it does not negate the fact that Mr. Harding received the dividends, paid taxes on the dividends, and then lent the money back to the Robbins Company. But for the fact that he had lent it back, that would have been part of the marital estate. There's no doubt about that. So the court should have valued the shares or the promissory notes at face value. And there is both a practical effect on that, a negative effect, and also a theoretical negative effect for the court's failure to do so. On a practical basis, the notes call for a 5% annual interest, which the company would have either paid to Mrs. Harding or would have accrued on her benefit. But without acknowledging that the notes should be valued at face value, how do you calculate the interest that's due to her? On a theoretical basis, the notes are called to be redeemed over a period of time. And arguably, the company could say, well, we no longer know what the face value of these notes are. The court did not gave us a decision where there's no value to these notes. It chose not to value the notes. So when it comes time to redeem the notes, at what value are they going to be redeemed? So the court should have valued at face value. With respect to, and I know I've been arguing kind of backwards, but with respect to the second assignment of error in the court finding that the company was in financial trouble, which I think was I believe the evidence shows in the record that was the driving impetus behind the court's decision not to instruct the company to redeem the shares and not to value the shares or the promissory notes at face value. The manifest weight of the evidence shows that the company was not in financial trouble. The company's chief financial officer testified that the notes were refinanced because of a breaching covenant. And he further testified during deposition that he was quite surprised that in fact Key Bank and Huntington Bank and JP Morgan Chase weren't interested in continuing their relationship because this had occurred in the past without any incident. There's also evidence on the record that the company was beginning $280 million worth of intensive capital projects, and they needed additional financing to start those projects in 2013. So the company would have required additional capital regardless of their whether they had breached the covenants or not. And we know for a fact that from 2009 through 2013, the company had net earned profits of in excess of $54 million, and they were projecting for 2014 through 2017 net earned profits of $47 million. This is not a company that's in financial trouble. It's a company that's transitioning and needs working capital. And we know that because of the interest rate that was charged on these loans, which was 11.8%. And Husband's expert even testified that this is the interest rate that he would expect a company to pay when they're reporting strong financial results. So clearly the judge's reasoning for not valuing the notes at face value and for declining to instruct or order the company to redeem the shares is against the manifest weight of the evidence. Lastly, if this court should decline to reverse the court's decision in part and instruct the court to order the companies to redeem Mrs. Harding's shares at $3,500 per share, we would ask that this court remand the matter for new trial and order the court to have the defendants produce all the discovery necessary. Because the only problem that we really had during the trial was the fact that we were always working behind the 8 ball. This is a huge company, averaging sales around $240 to $320 million a year.
Publicly traded?
Excuse me?
Publicly traded.
Not publicly traded, but private company, closely held, but operating on at least 4 continents, 16 different countries. And it's absurd to think that a woman who's running a beauty salon in Hudson and a family who lives in Hudson would produce almost twice the amount of documents with respect to financial disclosures as a $300 million a year company.
Let me ask you a question. I know you're arguing this issue last, and that's completely your prerogative. But if we were to agree with you, wouldn't that pretty much root out everything else?
Well,
Because you're saying, I don't even know if I got a good deal because I didn't get the discovery I needed to really evaluate the financial condition of.
and that's fine, Your Honor. I would be absolutely fine. And I think the reason there is such a need to have the complete discovery, the perfect example is what I put in my brief, is the fact that at trial, we couldn't even reconcile from Robbins International to what Robbins Company reported, to what husband reported on his tax returns, the amount of dividends that they received. How could we know that the proper support was awarded? How could we know what husband really has if we couldn't even reconcile the compensation? And the dividend schedules and the compensations schedule were 2 items that we asked the company to produce out of, once we were limited to 10, and they still refused to produce it.
But the point of that is, too, it can cut both ways.
I understand,
Okay.
but I'm confident that we would get to the right answer.
I don't think you told me at the beginning, did you want to reserve some time? But
Yes, I did
Okay.
say that we want to
Okay,
reserve.
all right. You're at 3 minutes, so why don't we go ahead it's up to you if you want to proceed or not.
Do you have any other further questions for me, Your Honors?
Evidently not.
Then I'll do the rest of it.
You may.
May it please the court, my name is Todd Mizzle. I'm here on behalf of the appellee Douglas Harding. Also here at the council table is Andrew Silligy. We're going to split time. I intend to do 10 minutes. Anything that I have left over will be taken by Mr. Silligy. Also at council's table is an associate of my firm, Sarah Hottie. One thing I'd like to kind of clear up in a misconception in the briefing is that there are always statements that these are husband's company. Husband is a minority shareholder, owned 12% before the divorce, owned 6% now, cannot control in any way this company. All decisions.
What difference does that make to the case?
Well, I think there's an implication in this case that husband drove these decisions of the corporation, and that's completely not true. He didn't even participate in any of those discussions, and that's another point. All the decisions made, husband during this case actually notified all the shareholders that these shares would likely be divided in the divorce, and that gave the remaining shareholders in the company a chance to look and see if they wanted to redeem under the closed corporation agreement. It was the 88% interest in shareholders that decided not to do that under the terms of the closed corporation agreement. Mr. Harding did not participate in any way in those discussions, and that's supported by the record. There are also arguments in the brief as to disentanglement, and it is our understanding that it is a goal to disentangle whenever possible husband and wife in business. This wasn't a case where that was possible, and the reason is this business, and there were 2 valuations, regardless of whose valuation you took. Wife's expert said that the shares in total were worth about $11 million. Husband's expert said they were worth about $2 million. There just wasn't enough other marital assets to offset this big of an asset, and to award just to one party and then offset it with other marital property, or to have a promissory note that could be possibly repaid. I direct the court, and it's in my brief, to DeMarco versus DeMarco, the 10th District Court of Appeals. that has a similar case and determined that when disentanglement is impossible, it's not an abuse of discretion to divide in kind the shares between the parties. One of the things that and I think what counsel has said today is what he really wants is he wants the court to order the trial court to redeem these shares that were transferred pursuant to the divorce decree. Half of husband's shares in TRC are transferred pursuant to the divorce decree to wife. The issue that they want to raise is whether the court should have taken an additional step of ordering the company to buy those back at an agreed value. There's actually no obligation for the company to do that under the close corporation agreement. They have the option, but not the obligation to repurchase under these situations. There's some discussion about having done that previously, and while it's true that there were some redemptions for shareholders under this optional language during that time, those were all done before there was a refinancing due to the breach. There was a breach of covenants with Key Bank, and as a result of that, the Robbins Company had to seek refinancing and had to go to a lender of last resort in doing that. All of those obligations were undertaken prior to that. When there's a discussion about Mr. Verrost and Carley having redemption basically subordinated notes on that, those were all created before the refinancing. There's evidence at trial that this would, and the only evidence I believe that was set forth at trial was a statement by Mr. Lebowski, who was the CFO of the company, who said that basically redeeming these shares would violate the covenants of the loan agreements with the new financing company, which is Crystal Financial. So there's two issues that the court looked at in exercising its discretion to the extent that it had it of ordering this redemption. And one is it would be ordering the company and its shareholders, which is not Mr. Harding, to redeem these without any authority in the close corporation agreement to do it. And the other was testimony that there were certain covenants in place that restricted such a transaction. I don't think there was any abuse of discretion in this case by the trial court in ordering as it did. Once the court determined to split these shares in kind, there was no obligation that he then separately value these. Again, there's no dispute that each share in option of the Robbins Company holds the same value. White's expert testified that each share in option was worth $2,900. Husband's stated that each share in option was worth $522. If they have an equal number, it's equal value. It's axiomatic if that's the case. And the 8th District Court of Appeals determined in Sachs versus Rigda that this was just the case. In that case, it's exactly what the court did. There were 42 shares that were held by wife. The court just split those in half, and when the husband argued that there was no value, the court said there's no prejudice in that situation because inherently an equal amount of shares in the same thing is going to have equal value. So that, again, that case was Sachs versus Rigdon, and that's an 8th District Court of Appeals case. There's an argument about the promissory note that I don't quite understand, and that is that it should have been determined valued at face value. What the court did is said, okay, what it did is it assigned all rights to payment to the husband to any interest or principal under that note, half of it to wife, half of it to husband. So there's a promissory note out there that has a schedule of payment. And it was also recognized that this note is subordinated to Crystal Financial. So if there is a payment, and the first payment would be 2017 and it's set for over $600,000, that payment would go principal and interest equally to wife and husband at that time. Now, there was some suggestion that the court somehow changed that the amount that would be due under that note, but that's a separate legal obligation under the note. It doesn't matter if the court valued it or not, it doesn't matter. The legal obligation under a note is to pay that amount. And as long as the subordination doesn't keep that from happening, keeps the payment from not happening at all, the amount that what husband and wife are going to enjoy under it are equal. Even the statement that it would be valued at face value doesn't really make any sense with a note that matures it's graduated and does not fully mature until 2027, and one that's subordinated. The present value of that obviously wouldn't be the face value. All those things are discounts that are taking it to effect. But in any event, because of the way the court did it, assigning payment equally between husband and wife, they're going to have an equal benefit no matter what in the future. There was no abuse of discretion in doing that. Again, there were no uncured discovery abuses in this case. The pretrial that is discussed in the brief is one in which parties came in, and as I understand it, what happened is that one of the objections that had been made by the companies is that the questions were overbroad. Wife agrees that over 5,000 documents were produced, paper documents, pages, were produced by the company during this. This was voluminous discovery. When there was an argument about more, the court asked the plaintiff's attorney who was there with his expert for the valuation what they needed. They gave a list of 10 additional items, and those were eventually met by the corporation, as I understand it. I don't understand how the abuse of discretion comes into play under those circumstances. Again, if there is some disagreement as to what went on during that, I believe that there were many things that the wife's counsel could have done. They could have demanded that the court go on record to determine what was said. The other things they could have done here to show is they could have tried to do a statement under Appellate Rule 9 to preserve the error. They haven't done any of those things. So I don't think there's been any demonstration of error. Again, there are cases out there, including what I cited as Stark versus Government Accounting Solutions, again out of the 10th District. The trial court doesn't err in denying plaintiff's motion to compel when plaintiff fails to narrow or restrict his discovery request. I also filed a motion to strike in this case, and I'm going to go quickly on this one. In the reply, there were several statements that were taken not from the trial transcript at all, but from a filed deposition transcript, and cited these were statements of the husbands. That transcript was in no way incorporated into the trial itself. It wasn't read in lieu of testimony, or it wasn't used in any way that would put that before the trial court in making its determination. It was just filed, and there are cases that I have stated, including Vodensky versus Ohio Health Corporation out of the 10th, and H.D. Steele versus Weston Hurd, that say just that. I mean, a trial court doesn't have to go and look at file depositions that weren't in any way incorporated into the trial to make its determination. And obviously on appeal, the Court of Appeals shouldn't look at those things either. With that, unless the panel has any questions for me, I'm going to cede the rest of my time.
Thank you. You may proceed.
May it please the court. Good morning, Your Honors. My name is Andrew Salagi, and I am counsel for Appellees, the Robbins Company, and a group of real estate holding companies that are collectively referred to in the briefing as the Robbins-related entities. As you have heard, the Robbins Company is the appellee husband's employer. On appeal, as the issues relate to the Robbins Company and the Robbins-related entities, we view our involvement as being quite narrow, and it specifically relates to the fifth assignment of error. As you have heard, the trial court ordered that the wife receive 1/2 of the husband's shares in the Robbins Company. Now, this stock is encumbered. The shareholders are subordinated creditors pursuant to a prior refinancing agreement. Given this subordinated status, the trial court granted the wife's shares in the Robbins Company subject to the same restrictions and conditions as all other shareholders within the company. Now, given these circumstances, this was a reasonable and equitable decision by the trial court. Now, in her fifth assignment of error, the wife now asserts that the trial court erred when it failed to order the Robbins Company to redeem this encumbered stock. In short, the wife does not want the stock. She wants to be cashed out for this stock. And in so doing, she wants the court to order the Robbins Company to pay her cash for the stock through a forced redemption. What the wife wants here is just not possible for a couple of reasons. And before I get into those two specific reasons, I do want to point out that the wife has a remarkably high burden to satisfy here. That is, she must demonstrate that the trial court abused its discretion. Unless she can satisfy that high standard, her appeal on this issue must fail as a matter of law. Going to the two specific reasons why she cannot succeed on this issue. First, as has been stated, the stock is encumbered. The Robbins Company is not a publicly traded company. Shares are not easily or immediately simply able to be traded, sold, or otherwise redeemed or cashed out. Rather, it's subject to the terms of its closed corporation agreement, and it's further restricted by outstanding debt and prior refinancing agreements. The wife's interest in the stock, just like the husband and all other shareholders, is contractually subordinated to another entity. The wife, however, wants to ignore this subordinated status and essentially wants this court to create a special class of shareholders whereby she personally benefits. There's just no contractual or legal basis for this to occur. The second reason why she cannot succeed on this issue is due to the closed corporation agreement itself. The Robbins Company is bound by the terms of the closed corporation agreement. Nothing in the terms of that agreement requires the company to repurchase the shares under these circumstances. In coming to its decision, the trial court respected the terms of this closed corporation agreement. What the wife wants, however, is for the court to ignore those terms and rewrite them so that she can benefit. In the end, the trial court recognized that these two separate, independent impediments to a forced redemption under the circumstances. Therefore, it reasonably and equitably divided the stock the best way that it could. It gave the wife 1/2 interest in the Robbins Company, subject to the terms and conditions that the husband and all other shareholders have. There's just no basis to suggest that the trial court's decision in this regard was unreasonable or unconscionable, such that it constituted an abuse of discretion. So with that, unless there are any other questions, I yield.
Thank you.
Your Honor, how much time do I have left?
We have 2 minutes.
Thank you. Your Honor, husband is the second largest shareholder in the company, a member of the board of directors, and in charge of the company's sales throughout the world. So it's somewhat naive to just call him an employee of the company. Second of all, what my opposing counsel failed to mention is that the company's valued husband's shares at $3,500 per share, or $15.5 million. That's the company's value. We argued all along that the judge should have used the company's value as the closed corporation agreement requires. And we begged the question, if the judge honored the closed corporation agreement for the issue of the repurchase, why wouldn't he honor the closed corporation agreement for the purpose of valuing the stock? Third, wife is not asking for anything other than what all other disassociated shareholders have been subject to since 2009, because there's evidence of a 5th redemption that occurred in 2009, 109 shares that were redeemed at the agreed value of $3,000 per share. Every disassociated shareholder with the company has had their stocks redeemed, and it is a false argument to say that the Crystal Finance agreement prevented that, because if you look at Plaintiff's Exhibit 19, which is the finance agreement, it clearly shows that the company is allowed to redeem the shares, just not allowed to pay any principal. But there's an accommodation made for that as well, because they're allowed to pay interest on the outstanding principal until it can be paid by the company. All wife asked for is that her shares be redeemed pursuant to the terms of the closed corporation agreement, as the company has done for every disassociated shareholder. Nothing more, nothing less than the same treatment that other shareholders receive. And why? Because again, she's receiving no economic benefits from this company. Why? While the remaining shareholders are, and that's why it was an abuse of discretion. The issue of Sachs is really not relevant, because in that case, it was an ancillary asset to to the family's divorce. Here we have the party's single largest asset, shares at the company value at $15.5 million, and wife has no access to that. Yes, that is an abuse of discretion. Then we have this whole issue about the, Mr. Mazzola said, as I understand it, the fact of the matter is Mr. Mazzola was not present at that pretrial. And this court does have precedent in Carter versus Carter, where it says that when a decision is made that rewards a party's willful obstruction of his opponent's good faith discovery effort, that is suspect. The trial court should not have allowed the companies and the husband to disobey it and not produce discovery and then reward them by limiting it.
And you're out of time.
Thank you. Thank you very much, Your Honor.
Thank you. Thank you. The court will take the matter under advisement and issue a written decision that will be mailed to both sides as well as released on the court website. Thank you very much. And the court is adjourned until next week.